And so Regulation 3ZA says that you have no right of appeal unless a revision has been considered, and this only applies to cases that happen after 28th of October 2013. So there's still cases going around that date from before that, and they're not affected by these new rules. And the second thing that has to happen for mandatory reconsideration rules to apply is that the claimant has been sent a written notice of decision, as is always required when the DWP takes a decision, and that notice has to include a statement that the right of appeal will only lie if the DWP has considered, has reconsidered the decision. So you've got to have a decision that includes the words, this is a mandatory reconsideration notice. The notice has to inform the claimant of the time limit for the revision. And if it doesn't, then that can mean that the time doesn't start or it's not governed by the mandatory reconsideration rules. As always, you've got to be told about your right to request written reasons if you haven't been sent the written reasons. But I think that's increasingly rare these days. I mean, ESA decisions always include the scores and enough written reasons for you to not get this extra 14 days to do with requesting written reasons. One of the big impacts of this mandatory reconsideration change is that it's changed the rules on late revisions, late applications for revision. So this is the rule where you normally have to ask for a revision within 1 month. The regulations have been changed so that a late revision can be admitted as before, where the application is received within 13 months of the decision and the decision maker thinks it's reasonable to admit it. And there are special circumstances that made it impracticable for it to be lodged within the usual 1 month limit. The main thing to remember here is that longer delays need better reasons. If you've only missed the 1 month deadline by a short while, then you are likely to have your late application admitted without too much difficulty. But the problem, as we'll come to in a moment, is that if the DWP decision maker doesn't think it's reasonable to admit, then that's the end of the line. If your request is late, then you can't take the thing further to appeal under what they think the new rules say, although we will see later that there is a way to challenge that. So this slide is looking at the procedural aspects of mandatory reconsideration. First off, the DWP is always going to send out 2 copies of the mandatory reconsideration notice, and that's because the claimant can then have one to keep and one to send to the tribunal when the claimant appeals under the direct lodgement procedure. There is a new appeal form. It's called the SSCS1. That's Social Security and Child Support form number 1. That's the new appeal form that replaces the old DWP GL24. Now, while it is said in the HM Courts and Tribunal Service information and the DWP information that you absolutely must send a mandatory reconsideration notice in to have a chance of lodging your appeal properly, there are exceptions. The tribunals have power to waive rules. They waive the tribunal rules in exceptional cases and where they think it's necessary. So there's this Rule 7 of the Tribunal Procedure Rules, and using their power, the tribunal can admit an appeal even if you haven't supplied a copy of the mandatory reconsideration notice and you give a reason why not. Like, for example, you've lost both copies of the notice, which is, sending claimants information and expecting them to have it to hand when they need it is not always going to happen. So one possibility is where somebody's lost the mandatory reconsideration notice, and another possibility would be where the claimant can provide enough information to prove that a mandatory reconsideration did take place. Maybe they never received it, but they can prove that it has been done. The final point on this page is to say that the only time limit we have in the system is a time limit that comes at a later stage. There's no time limit for the DWP to carry out the mandatory reconsideration in, but at the later stage, once the appeal has been lodged, then they've got 28 calendar days to provide the appeal response. That's only going to be in place from October this year, and they can ask for an extension as well if they need one. This page is just to remind people of rules that haven't really changed. If you sorted out your mandatory reconsideration but you've been late in submitting your appeal, again it's similar sort of process. You've got to give reasons, state special circumstances, and your appeal could well be admitted late because the tribunal's got an overriding aim to deal with cases fairly and justly, and they've got to take into account your reasons, and the longer the delay is, the better the reason needs to be. If you're only briefly out of time, then it should be admitted. The other thing that tribunals do in exercising their role of trying appeals fairly and justly is to look at the merits, and so it's going to be more likely that you'll have an appeal admitted where it's a really big important case with a large amount of injustice that could happen if it wasn't allowed to proceed than if it's a minor case or a weak case. That's nothing to do with the new mandatory reconsideration rules. That's just a refresher on what the late appeal rules are. So that's an outline of what the new rules are and how they affect all appeals for all DWP benefits. So problems, this is in two parts really. The main issue that I'm sure you've all heard of is what's going to happen to people who are on ESA and currently can get ESA pending appeal, and they're not, under the new rules, able to get ESA during the mandatory reconsideration period. What are they going to do? And then the second problem is that if you miss your 1 month deadline and try to apply for a revision late, it's possible that the DWP considers that you haven't got good reasons, they don't revise, they don't consider whether to revise, and therefore that's the end of the line in terms of your appeal. You no longer have the possibility of getting that late revision request considered by the appeal tribunal, which might have a different opinion on it. So we're going to go first of all to problem number 1, ESA pen revision, and just do a recap of what the normal rule is and continues to be for people who are appealing about ESA. So starting point is that in order to get ESA, people have got to have a limited capability for work or be treated as having it. And Regulation 30 of the ESA regs says that people who are pursuing an appeal are treated as having limited capability for work. So this is what makes ESA so unusual. Out of all the benefits that there are, no other benefit can you actually have your claim refused and still carry on getting any of that benefit. But this Regulation 30 provides for that with ESA. Furthermore, the bullet at the bottom of the page says why it is that you don't actually have to make a new claim for ESA when you're appealing. It carries on without the need to make a claim for people who are pursuing an appeal. So the government has been very clear that you cannot be treated as having limited capability for work while you're seeking a mandatory reconsideration, and they were asked to amend the rules, but they said they wouldn't amend the rules to make the mandatory reconsideration period the same as the appeal period. So you've got no entitlement to ESA during the mandatory reconsideration unless you can avail yourself of one of these possible solutions. Actually, so I'm going to go straight into the solutions here for the ESA problem and then come back to the late revision problem and the solutions to that. So we're going straight into what can you do if you can't get ESA pending mandatory reconsideration. There's 4 possibilities. Firstly, you can claim job seekers allowance during the mandatory reconsideration. Secondly, there are possible ways of forcing the DWP to get a move on and produce a decision so that you can get straight on to appeal and get your ESA back. Thirdly, you can reclaim ESA, but only if you've got a new condition or a worse health condition. And fourthly, there are some other ways which are a little bit harder to imagine, I think, some of them, and very much the fourth in order of likelihood, I think, but I'll come to them after the other three. So the first possible solution, the most likely thing that people can do, is to claim job seekers allowance. The problem always being that they're not well enough to be actively seeking work and taking jobs. That's the whole reason why they're claiming ESA. So it's kind of problematic for them to comply with conditions. So we need to take a close look at these conditions. So first of all, the actively seeking work definition is that you've got to be taking such steps as you can reasonably be expected to take in order to have the best prospects of securing employment. And so I've highlighted reasonably in there, and so it connotes various things like your individual skills and abilities, your individual limitations, and other factors like homelessness. What is reasonable in your particular situation, and being a government department, job centres got to always behave reasonably, and if they are unreasonable in their expectations of what you as an individual with your particular skills and limitations can do, then they can be taken to task over that. By the way, when you claim job seekers allowance during the mandatory recon period, it in no way affects the ESA decision, which was a prior decision. The appeal is always going to be looking at the decision as it was before you claimed job seekers allowance. So there's no bearing of well, you said you're actively seeking work now, so make up your mind. It's just not going to be relevant. So this reasonable restrictions is the thing that is very important, and the rules are that you can restrict your actively seeking and your availability for work in any way, provided that the restrictions are reasonable in view of your physical or mental health condition. So it's possible for a claimant to say that it's only reasonable for them to have part-time work because they can't cope with anything more than that due to mental health condition or fatigue. Now, it's an area where the claimant and the job centre advisor have a power imbalance. The job centre advisor's got discretion to ask for a wide variety of things, and the way of challenging the reasonableness is going to be through that. If you say I can only reasonably do X, and the job centre advisor says, well, you've got to do Y, and then you don't do Y, and then you get sanctioned, then you're going to get a decision which you can appeal in the normal course of events, and that's when the issue about whether it was a reasonable restriction in the first place will come up. So another example, I mean, this was quite a far-fetched example that we came up with at on the previous workshop. Somebody who gets panic attacks on public transport, so they can't go on the bus to work, they haven't got a car. It's conceivable that they can reasonably restrict their availability to work at home or within walking distance of home. So moving on, another thing that you can do while you're claiming job seekers allowance during the mandatory recon period is to actually be off sick in the same way as an employed worker can be off sick from their job. You are allowed to take up to 2 weeks off sick a year, 2 weeks in one go off sick while you're claiming job seekers allowance, and you're able to have 2 such fortnights in a year. So it's a normal procedure for claiming sickness, for claiming a sick, which is that you self-certify for week number 1 and you go and get a doctor to give you a medical certificate or fit note for week number 2. You could conceivably claim job seekers allowance when your mandatory recon period starts and be off sick for 2 weeks. You can't go straight into the second fortnight because the 2 fortnights have to be separated by at least a day. But given that, Esther McVey, the Minister for Disabled People, said in December, I think, that straightforward ESA mandatory reconsideration should take 14 days, that might be enough to tide somebody over the mandatory recon period. Another possibility while you're on job seekers allowance, if you're disabled, is to ask for a referral to the job centre DEA, the Disability Employment Advisor. We heard last time that somebody was successful in asking for DEA interviews for their disabled clients, and because the DEAs are so few on the ground, the delays were so long that they were back onto ESA pending appeal before the JSA requirements could be imposed upon them. Another thing that you can do while you're having to claim job seekers allowance during the mandatory recon period is to sign on by post. So just to outline how it works here, you've got to send a signed declaration by post. You may still have to take part in interviews at the job centre, but if you can't get out of the house, you may be able to liaise with the visiting job centre advisor. It also, I mean, I haven't heard of this before we did this workshop, but I'm assured that you can sign on by post, and apart from this condition at the bottom, it should be okay. The condition at the bottom is that if you don't get your signed declaration in time, then your job seekers allowance will end unless you can show good reason for the delay. So that's the job seekers possibilities, various possibilities while you're claiming job seekers allowance instead of ESA. And next up, the second possible solutions lie in trying to get a decision on mandatory consideration sooner rather than later. So, as I've mentioned, there's no time limit for the DWP to do a mandatory reconsideration, and as I just said, Esther McVey made this comment in November about how they should take 14 days. So there are things you can do if the DWP does carry out its process as soon as reasonably practicable. So this is a general rule for all administration of government. Things should be done as soon as reasonably practicable, and there's a few cases on it in terms of social security law. I don't think they're particularly helpful, but the CPAG did one there that decided that it can depend on the volume of cases and availability of decision makers. So you can imagine it's going to be a lot of mandatory reconsideration cases to be decided. So that case probably isn't that helpful, but it's there for people to look up if they get this problem. And secondly, there's a case that highlights how, in order to get a sooner rather than later decision on your particular case, it's going to be important to show why your particular client is going to be worse off waiting rather than all the other people who have to wait in the same way. If you can show that they're not taking a decision as soon as reasonably practicable, then your remedy is judicial review there at the bottom. You need a solicitor to start a judicial review proceedings in court, but if you're an advisor, you can write the letter before action. And so if you can write a well-worded letter explaining the things that are mentioned above in the bullet points about how much worse it is for your particular client, or how bad the delay is and how it's breached the assurance given by Esther McVey and so on, and you will take judicial review proceedings if you don't get a quick answer, then that could well bring your case to the top of the pile and just slow down some other people's mandatory reconsiderations. It's just a sort of question of tactics. We are here focusing on ESA cases, but thinking about other benefits, I mean, the mandatory reconsideration process is for the DWP to ask to get better evidence, get more evidence, and for you to have the opportunity to provide evidence that you haven't yet provided. So in something like a PIP case, they'll go through the normal process of asking you if you've got anything else to say, and you probably want to say yes, because you don't have any PIP anyway to lose while you're waiting, and you get a chance to provide this further evidence at this stage, and then again later at the appeal stage if necessary. So you might as well avail yourself of that opportunity to draw out the mandatory reconsideration process and get your better evidence in, and that would apply to any other benefit except for ESA. So with ESA cases, it's the exact opposite, and they ring you up to ask you if you've got anything further to add and would you like to supply it, and then you'll get an extra month to do so. Then even if you have got any good new evidence, you should say, no, I don't want to provide it at this stage. Get on with providing my mandatory reconsideration, and that way you'll get back onto ESA pending appeal as soon as possible. This next one, number 3, reclaim ESA, will only apply if you've got a new health condition or a worsening of your existing health condition, because that allows you to make a new claim, new set of circumstances, get assessed all over again. But if that isn't the case, then there's absolutely no point in reclaiming ESA, because it will just go into the same mandatory reconsideration process that you're already in. The next bit is to look at these other challenges. So this is quite a hard one to understand, I think. So Regulation 30 of the ESA regs, which we looked at earlier, that's the one that says why claimants can get ESA pending appeal in the first place, and the government has been adamant that you cannot get ESA pending reconsideration. But the regulation says that you can get ESA where you've made and are pursuing an appeal against a decision that you don't have limited capability for work, etc. So can the law be stretched? Can the interpretation of this phrase, has made and is pursuing an appeal, be stretched to include mandatory reconsideration? There is, in the background to all of our judicial system, there is the Human Rights Act Article 6, the right to a fair hearing. Now, the reconsideration process is internal by the same people that decided against you in the first place, so it's not a fair hearing, it's not independent, so it's in breach of Human Rights Act Article 6. And the gist of this argument is that if the only way that a tribunal could avoid there being a breach of Human Rights Act Article 6 is by stretching the interpretation of pursuing an appeal to cover pursuing a mandatory reconsideration, then they might just do that. So this is the sort of thing where CPAG is looking for test cases. They need an example of somebody, probably, and the worse, the more distressed situation they're in, the better it is from the test case point of view to try and see if you can pull off a stretching of the interpretation like this. Next is specific challenge around people with mental health conditions. So last year there was a very famous breakthrough case that found that the work capability assessment was discriminatory against people with mental health conditions. It was the one that was brought by Mind, Rethink and National Autistic Society, and it was saying, for example, autistic people who don't have a clear understanding of how their condition affects them and therefore don't answer the questions to show why they need to be classed as having limited capability of work. They're being discriminated against by a system that's not treating them fairly as people with that kind of mental health condition. So on the back of that discrimination against people with mental health conditions, to have a mandatory reconsideration rule that compounds this discrimination could lay it open to a discrimination action. So it's kind of like the same discrimination action that got people with lack of self-awareness and other mental health conditions to win this case last year. That argument can be used again about this mandatory reconsideration process because it's that much worse for that discriminated against group of people. After that, we have possibility of launching a challenge around the public sector equality duty. So this slide sets out the public sector equality duty. There it is. Public authority must have regard to the need to eliminate discrimination, etc. We had a breakthrough case on this last year, which was the Independent Living Fund case, where it was decided that the closure of the ILF in 2015, I think it is, had not been consulted upon properly, and therefore the decision to close it was unlawful, and that all took place under the Equality Act and the breach of the public sector equality duty. Again, it's a case of looking for discrimination arguments, which seems to be where a lot of test cases are won.